It's great to be here at the ABA White Collar Conference, and it's great to catch up with folks I don't get to see. One of the pluses or minuses of having practiced in New York and San Francisco and sort of in Houston is that I have friends from all those cities, and this is really the only occasion where I get to see them all. So it's really a wonderful event for that. As Ray said, for almost 2 years, I've had the pleasure of leading the criminal division of the Justice Department. We've got more than 600 lawyers who do all sorts of different kinds of cases. We've got 17 different sections. I'm not going to list them all. But we've got the fraud section, which has more than 100 lawyers and is the biggest white-collar prosecuting unit in the country. We've got the asset forfeiture and money laundering section. We do public corruption. We do cybercrime. We do international narcotics trafficking, transnational organized crime, and a lot of other things that I'm not going to list here. One thing that we do in the criminal division is we try to focus our efforts on national things and even international things. We try to focus our efforts on bigger cases and cases that maybe span multiple districts, so that maybe one U.S. Attorney's Office wouldn't necessarily be interested in doing the case or may not have the resources to do the case. We also find that because of our focus on bigger cases and national cases, we tend to have a lot of international cases. And that's one thing I really want to talk about today, because that's been a big change since the last time I was at the department. When I was at the department before, it was really the rare case that had an international reach, where the evidence was overseas, the defendants were overseas, or some of them were overseas. But now we're dealing with really international, worldwide criminal schemes. And I have to say that certainly from the vantage point of the criminal division, when we're doing corporate fraud, which is what I'm going to talk about today, since that's what I think is of interest to most of you, everything is really transnational. And corporate misconduct, having to deal with international regulators, international enforcement teams, that's really the new normal for us in the criminal division. It's driven by a variety of factors. Partly it's driven by the increasing global scope of U.S. companies and also the increasing global scope of foreign companies, many of which are listed on various exchanges in the United States, so they're subject to our laws. Another thing that has really changed the face of crime and the face of corporate crime since I was last in the department is the internet. The internet has changed everything. You all know that from the fact that you're all checking your phones right now. But go ahead, keep doing it. I would be doing it too if I was sitting back there probably. But and I also should have noted when I started that, for those of you who are for my panel yesterday, you'll note that I did not wear red today. And that's befitting my somewhat more bland and boring role in this particular speech. But the internet has really changed crime. It's changed the ability of criminals to just be sitting in their offices or their homes, some far-flung country, and engage in criminal activity that victimizes people in the United States. It's enabled traders, a trader in Singapore and a trader in London and a trader in name that other country, to engage in far-flung conspiracies, even sometimes without ever entering the United States, but affecting the United States. And our efforts against cross-border crime really reach every nook and cranny of the criminal division. There are some obvious places. There's the fraud section. There's the cybercrime section. But one of the biggest problems we see on the internet that's international is child exploitation. There are child exploitation groups all over the world who are trading and selling and manufacturing child exploitation materials and using the internet to do all of those things. So to address the international scope of crime, we've really had to upgrade and improve and create relationships with overseas law enforcement and overseas regulators. These relationships have been growing. The FCPA was probably the space where a lot of them started. We got to know the regulators in the Netherlands and name that other country through FCPA cases, but the relationships are now expanding to a lot of other different kinds of cases. And they've already started to yield some results, some very significant results. And this started long before I became the AG of the criminal division, so I'm not taking credit for it, and it's just the way of the world. It's just a natural evolution. But let me just talk a little bit about a couple things in the corruption space, in the FCPA space. The FCPA is something that some people feel very strongly about, that it's a good idea, some people feel it's a bad idea. We think it's an incredibly important area of prosecution. Foreign corruption, as you all know, is rampant in a lot of the world. I would say it's rampant in the majority of the world. And it really undermines countries, it undermines civilization, keeps people in poverty, it undercuts the rule of law, And it actually does breed other kinds of contempt for the law. It breeds crime. It breeds chaos. It breeds terrorism. And those are at the extremes. But there are a lot of countries where the respect for the law is so low that there really is just no real validity or integrity to the government in those countries. It also interrupts the ability of American companies to play on a level playing field in these countries and to send investment to these countries. So we think that the FCPA is really important. And I want to just talk about a couple of examples of our recent work in the FCPA and how we collaborated with international partners to bring cases that probably 10 years ago we would not have been able to bring. Excuse me for drinking water. I also had a little wine last night myself, so not too much though. So about 2 weeks ago, the department, through the criminal division, through the fraud section, the asset forfeiture and money laundering section, and working with the U.S. Attorney's Office in the Southern District of New York, and I should say that we work in most of our cases as partners with U.S. Attorney's offices all over the country. We do bring some cases on our own, but we mostly work as partners with the U.S. Attorney. So 2 weeks ago, together with those groups and the public prosecutor in the Netherlands and the SEC, we were able to reach a coordinated resolution with Wimpelcom, which is a Netherlands-based telecom company. It's the 6th largest telecom company in the world, and its Uzbek subsidiary called Unitel. Unitel pled guilty to violating the FCPA, the anti-bribery provisions of the FCPA, and Wimpelcom entered into a deferred prosecution agreement as a result of its violations of the anti-bribery and books and records provisions of the FCPA. This resolution was a very significant one, partly because of the size of it, but also partly because of the unprecedented international cooperation that we had in that case. Wimpelcom and Unitel admitted that from 2006 to 2012, they paid $114 million in bribes to a single government official in Uzbekistan. And they paid that money because that official had influence over who got to have a license to be a telecom operator in Uzbekistan, who got to get in the market and who got to stay in the market. And that official got $114 million from those companies alone, Wimpelcom and Unitel. And the payments were incredibly complicated and hidden. They were structured through shell corporations. They were moved through accounts all over the world, in countries all over the world. In any event, Wimpelcom also didn't have internal controls, not shockingly. And they also, at one point, the board of Wimpelcom wondered, is there some FCPA problem here? We really need to get outside counsel in to look at this and see if there's an FCPA issue. So certain managers within Wimpelcom, they brought in outside counsel, but they failed to tell outside counsel. And we see this a lot in the criminal division, where people give us, here's what our lawyers said, but then we find out that they didn't actually tell the lawyers the critical facts that they needed to know to form an honest and well-formed opinion. So information was withheld. Outside counsel said, oh, we don't see a problem. And of course, there was a huge problem. So I think the case was made because we were able to trace money. Really, and I said 114 million, actually we traced a lot more than that, which I'll tell you about in a second, through various accounts all over the world. Without help from other countries, we would not have been able to do that. They executed search warrants for us. They got documents for us. They gave us bank records. They gave us information. The case actually was originally referred to us by foreign regulators. We worked with the Dutch prosecutors, who we ultimately resolved the case with. We worked with the Swedish prosecutors. We worked with the Norwegian prosecutors, the Swiss prosecutors, the Latvian prosecutors. We also worked with colleagues in Belgium, Ireland, France, Luxembourg, and the UK. That would not have happened 10 years ago. And because of all that great work, we were able to put together that case. Another important thing about the Wimpelcom case that's, I think, new and different is we have in the criminal division, in the asset forfeiture and money laundering section, a Kleptocracy initiative. And the purpose of the Kleptocracy initiative is to find assets that have been either bribe proceeds or assets that have been otherwise stolen, misappropriated from countries around the world, taken from those countries, and somehow used in the United States, either passing through the US banking system or purchasing assets in the United States. And it's an initiative that's fairly new. It's very difficult and challenging. It uses civil asset forfeiture to seize those assets. And we did that in the Wimpelcom case. What we did in that case was the corrupt Uzbek official, in addition to the $114 million that was paid by Vimpelcom and Unitel, also received hundreds of millions and more money from other companies who also wanted to be in the telecom space in Uzbekistan. And we were able to trace and freeze $850 million of that official's money in accounts located all over the world: Luxembourg, Ireland, Belgium, Switzerland. And we, again, could not have done that without the help of those countries. Another case in which we received a lot of help, and this goes two ways, by the way. They're not just helping us, we're also helping them. And I think in the FCPA space, we're seeing that a lot more cases are originating from reports from foreign law enforcement. And I'll give you another example of one of those. You're probably all familiar with the Alstom case. That was a French power and transportation company which admitted to paying bribes to government officials, in this case in multiple countries: Indonesia, Egypt, Saudi Arabia, the Bahamas, and Taiwan. And in Indonesia, for example, Alstom and its subsidiaries paid bribes to government officials in exchange for assistance in winning several contracts to provide power-related services, $375 million worth of contracts. Alstom eventually admitted its criminal conduct and agreed to pay $772 million, which was the largest Department of Justice FCPA settlement ever. We couldn't have gotten there without a lot of help from the foreign regulators. Alstom did not voluntarily disclose its conduct. When we found out about the conduct and approached Alstom, for several years they refused to cooperate with us. So instead of just hoping that they would eventually cooperate, we reached out to regulators and counterparts in these various foreign countries. And we got a lot of cooperation from those countries and were able to build cases against 5 Alstom executives. And at that point, Alstom eventually came in and began cooperating with our investigation. So the case came to us from the Swiss. People think, oh, Switzerland is impenetrable. We do a lot of cases with the Swiss government. They're not thrilled with the idea that they have to give us information, but they ask us for information, we ask them for information, and we do share. Indonesia, we worked very closely with the Indonesian Anti-Corruption Authority to help them prosecute the Indonesian government official who took bribes, and he's sitting in a jail right now in Indonesia as a result of that. We got a lot of help from France. People think France is a reluctant partner. We work with France all the time. France has a lot of challenges in the data privacy space, but we work with them all the time. We got a lot of help, as I said, from Switzerland, the UK Serious Fraud Office, Germany, Italy, Singapore, Taiwan. So those are 2 cases that I don't think 10 years ago we would have been able to make, because we didn't have those relationships, and now we do. And we're expanding our relationships, not with just countries like the ones I mentioned, but with a lot of other countries around the world. For example, I'm going to Argentina in a few weeks to develop a relationship which we previously have not had with Argentina, and hopefully that'll be sort of a salvo and an opening in relationships with countries in South America, which we have not had super strong relationships with. But with international collaboration and all of the good things that it brings from the criminal division's perspective, it also brings a lot of challenges. It goes back to that old saying that you probably knew, in those of you who are prosecutors, big cases, big problems. And then there was the analog, no cases, no problems. We favor the big cases even though they come with the big problems. Setting aside all the State Department-y type issues, the diplomatic issues, the logistical issues, there are a lot of other issues in doing international cases. There are a lot of thorny investigative issues and prosecution issues. So, for example, what happens when a foreign government has conducted surveillance that's not legal under US law? What do we do with that? What happens when one country grants immunity and we didn't, or when we grant immunity and another country didn't, or when we wanted somebody to plead guilty and another country wants to prosecute them? It's all very complicated. But over time, because of these relationships that I've been talking about, we've gained a lot of experience in dealing with these issues and understanding these issues. So, for example, last year, 2 traders at Rabobank were convicted in the Southern District of New York by the Fraud Section and the Antitrust Division of manipulating the LIBOR, the London Interbank Offer Rate. And the investigation involved law enforcement agencies from all over the world. I'm not going to list them here, but before our prosecution started, 2 of the 3 traders who were prosecuted were compelled to attend interviews by the UK Financial Conduct Authority, the FCA. And under UK law, failure to respond to a request for an FCA interview could result in penalties, including imprisonment. So 2 of these traders went in and were interviewed and gave statements to the FCA. Then a 3rd trader was told by the FCA that he was going to have to come in and give an interview, and they sent him copies of the first 2 traders' interviews, which he read. Fast forward, they're in the United States. The 3rd trader decides he wants to cooperate with the government. The first 2 traders are going to trial, which they did, and they make a castigar motion saying that his testimony was tainted because he had read their interviews. The government's prosecution was tainted because they knew what those traders had said, and they were able to influence their cooperators' testimony as a result. So the trial went forward. The defendants were convicted, and post-trial, Judge Rakoff held a castigar hearing to see whether there was, in fact, taint. And he concluded that there was not. He concluded that the defendants' compelled testimony in the UK was different, didn't influence the proceeding in the United States, and that the cooperators' testimony was derived completely from sources other than having read those 2 traders' statements to the FCA. So those are issues that we're used to dealing with now, and issues that I, frankly, when I was a prosecutor, wouldn't have thought of and might not have known what to do if a defendant made a motion like that. But the criminal division has gotten increasingly sophisticated about dealing with those complicated issues and working, in our cases, with issues that are created by different foreign laws. And it's very challenging, but it's also kind of very exciting, and it's kind of fun to deal with these issues. We're also using our relationships in corporate investigations. So if a company really wants to cooperate with us, but they're blocked by some data privacy law from giving us certain documents, we have relationships with their country's law enforcement agencies that sometimes can help, not always, but sometimes can help us navigate those data privacy laws and get the companies to have the ability to get the documents in those countries. We are also able at times when a company says, oh, we would love to give you the documents from France, but we just can't because of the data privacy law. We are able to use our relationships with countries on many occasions to figure out ways to navigate legally around those data privacy restrictions and get our hands on some of those documents. And we do see an unfortunate number of company counsel who say that they're blocked by data privacy when, in fact, a little bit of investigation by us reveals that, in fact, the data privacy law is not what we were told, and the documents can be produced. We have another thing we've done to try to meet the challenges of the international scope of our work is we have prosecutors who are really all over the world. We've got people on the ground we've got attachés in 8 countries. We've got people on the ground in 105 other countries, 60 permanently stationed, 45 on an intermittent basis. We have them in places you would think, like Paris and London and Rome. Those are among the most coveted positions in the Department of Justice. But we've also got them in Dhaka, Bangladesh, and places you might not, Pakistan, places you might not think of. We also have recently placed embedded a prosecutor with Eurojust in The Hague, and we also have a prosecutor who's going very soon to Interpol in France. We also are exploring the possibility of embedding additional prosecutors in the UK and other places. And likewise, we're being asked by foreign regulators to allow them to have prosecutors to come to the United States and work with us, and we're exploring those possibilities. We've also increased the resources available to our Office of International Affairs, which, as most of you probably know, does all of the outbound and inbound mutual legal assistance treaty requests that come into the United States and also that emanate from the United States from both federal prosecutors and state and local prosecutors. So they're really, really busy. We're staffing them up, and we have an MLAT modernization project, and we're really working to speed up the MLAT process. We actually just recently hired a new OIA director who's actually starting on Monday, who I'm very excited about. So we're hoping that OIA will continue to step up its game. They're working on a lot of things. They're working on the El Chapo case. They're working on the FIFA case. They're working on a lot of big, high-profile, big-ticket cases. We also are providing more, in the international space, we're providing more resources to the FCPA unit of the fraud section. We're in the process of hiring 10 new lawyers for that section. The FBI has also recently created 3 new squads to deal with international corruption, including FCPA and Kleptocracy. We're hoping that this will enhance our ability to make a really high impact on big cases, important cases, and to bring the right cases and to do it in a thoughtful and proactive way. I also want to talk a little bit about some of the other challenges that we see in these cross-border cases. As I'm sure all of you know who are defense lawyers, when we work with other foreign regulators, there's often an appetite among those regulators. I want a piece of this case. I'm working on this case too, and I want a piece of this. And we're familiar with the concept of piling on that the defense bar has written about and talks about, and we recognize that's an issue. We recognize that it's a bad idea. We recognize that there's a potential for unfairness when multiple regulators are seeking, basically instead of seeking their slice of one pie, they're all seeking their own separate pie. We recognize that's a problem. And we've been working very hard in the last few years to address that problem by coordinating with regulators and trying to agree in advance which portion of the ultimate resolution is going to be with which regulator. So, for example, in VimpelCom, VimpelCom paid about $795 million altogether, but that was divided among different regulators. It was divided among the Netherlands public prosecutor, the SEC, and the U.S. government. And it was done in a way so that we didn't make 3 pies and call them one. We really had one pie and sliced it up in those ways. So we're aware of that issue. We're trying to address that issue, and hopefully we are making strides in that direction. I also think that we also take into account when we're not talking with the other regulators, when they're imposing their own penalties, independent of what we're doing, we have taken steps to sort of credit whatever the company's going to have to pay to us, to sort of deduct what we know they may have to pay to another regulator in a separate investigation over which we have no control. So we did that in the Deutsche Bank case when the New York Department of Financial Services and a couple other regulators were seeking funds for essentially the same conduct that we were prosecuting. We basically reduced what we otherwise would have asked Deutsche Bank to pay to the U.S. Department of Justice. So I think that that's an important thing that we're trying to do. We're also trying to address the notion in the same way with individuals. We recognize that when we're doing, for example, and there have been some ugly turf battles in this space, such as in the LIBOR case when the UK wanted to prosecute the same people we wanted to prosecute, and there was a little bit of a race to the courthouse. And we recognize that that's not a good thing, and we're trying to avoid that. We're trying to talk earlier in the game with other foreign prosecutors and regulators who might be interested in prosecuting the case about what makes sense, what's the fairest thing to do, what's the most logical thing to do, what's sensible, who has the greater equities. So now it's not uncommon at all for us to stand down and let somebody else bring the case. Likewise, it's not uncommon for them to stand down and let us bring the case. So we really don't want a situation where individuals find themselves caught in the last minute of some turf battle between regulators, because we recognize that that's not right and that's not fair. So with all this talk of international stuff, I do want to say that the department is not trying to be the world police. We're not trying to be the global police force. But I do think it's very important, because I think the U.S. really is looked to by a lot of other countries as an example. And I think it's important that we be an example, that we set an example, that we vigorously enforce our laws, that we vigorously investigate wrongdoing and prosecute wrongdoing. And I think that by working hard with our international colleagues, we really do help, because the world is a very small place now, as you all know. Our financial markets are worldwide, and something that happens in Hong Kong reverberates in New York and vice versa. And I think it's really important that we be vigilant and we be aggressive, because that's the only way that we can really assure that we're protecting our markets, we're protecting our economy, and we're protecting our citizens. And we really have to work, in order to do that effectively, we really have to work with the rest of the world. That's what we're doing. That's the future of the criminal division. That's the future of criminal law enforcement in the United States. I think I can take maybe 2 questions if anyone has any, and then we'll go on to the ethics panel that I know everyone is actually here for. Yes, sir.
How do you decide how big the fine should be? What criteria do you
So the question was, how do we decide how big the pie should be, and what criteria do we use in deciding how much a company should pay? So we think that the numbers, whatever the number is and whatever kind of case it is, needs to be tethered to some kind of reality. So it could be the profits that the company made from some particular bribery scheme. It could be the profits that a company made from some other kind of scheme. It could be the trading profits. It's really case specific, but the consistent theme is we want to be able to justify the number by pointing to a particular transactional connection, if that makes sense. And one more question? Yes, sir.
What's the limit on jurisdiction?
What's the limit on jurisdiction? There has to be some connection to the United States. You know, we have plenty of crime to prosecute in the United States. We don't need to go enforce the Japanese laws. We have a lot of cases that, as I said, are international in scope, but have a very serious nexus to the United States in the financial space. Most international financial transactions at a high level at some point involve the U.S. banking system or the U.S. markets. We don't want bad money in the U.S. markets. So I'm not going to define the limit, but I can tell you that we're not interested in cases that don't have a U.S. nexus. We're not interested in manufacturing the U.S. nexus. But there are a lot of big cases out there, given the small size of the world, that really do touch the U.S. and affect the U.S. and harm the U.S. So that's more what we look at than some definite line in the sand. Okay, thank you.
All right, I think we're ready for Mark and his group. He may be, there's Mark.
Just come.
Yeah.
You call, we call.
You guys ready? Yeah. Okay. I'm starting with the math. Good morning, everybody. My name is Mark Schnapp with Greenberg Traurig in Miami. I've had the good fortune of having the opportunity to moderate a panel of really excellent people here. We'll start with Sung-Hee Suh, who is a Deputy Assistant Attorney General in the Criminal Division. Next to, I'm sorry? Oh, I'm sorry. Is this better? Next to Sung-Hee is Charlie Stillman, who is a legendary lawyer from New York who has he's a little shy about his opinions, so that's why we asked him to use this opportunity to break out. Next is Cheryl Scarboro, who was the former head of the SEC's FCPA program and is now a partner at Simpson Thacher. Next to her is Ira Raphaelson, who's had every possible position in the Department of Justice, including acting U.S. Attorney in Chicago, the head of a bank fraud task force. He's now the general counsel of the Sands, and Ira's made a point to tell me everybody that what that all shows is that he can't keep a job. And then next to him is the Honorable John Gleeson, who is a federal judge in the Eastern District of New York, and we overlapped very shortly at Cravath. And John has been an assistant U.S. attorney in the Eastern District of New York, a federal judge for many years, and is about to go into private practice. So anyway, our focus today is not really on how to do an internal investigation. I mean, I think we've probably heard enough about that, nor is it to attack Sally Quinn's memorandum, because I know you've heard a lot about that. But it does bring up some ethical issues which we want to address. So I want to start with a hypothetical with two variations, but the focus here is going to be who your client is and what your obligations are and how you make those decisions. So let's sort of start with a situation where you get a call from a general counsel of a company that the FBI is executing a search warrant at their premises. You call the agent and you want to find out what's going on. You also find out that they're investigating sort of high-level conduct at the company. The FBI has also done what they usually do, which is sort of herd all of the employees into a room and start to question them. So you get the call from the general counsel, starting from which, and this is going to sound silly, but do you start the conversation with, "I'm not your lawyer"? You give that person an upjohn warning that minute if you already know it's going to be an investigation of high-level people? Charlie?
Well, the first thing I would do is think back. There was a great lawyer in New York by the name of Boris Castellanets. And Boris was doing this work long before there were rooms full of lawyers doing white-collar cases. He was a totally great man. And Boris, at a moment like this, would have answered the question, "Who do you represent?" And Boris would have said, "I represent the situation." And you know, the truth is, look, there are obviously rules, and there's 1.12, et cetera, et cetera. And so you're grasping to do the right thing under a very tense moment. And forgive me, you know, the ethical thing is what really fascinates me about this. And I love to start answering ethics questions by the following story. So it's the story of a law student who comes home one night for dinner, and he's sitting at the table with his parents. His father is a dry cleaner's. And he said, "How's law school?" He said, "Oh, it's great, Dad. I'm having a great time." He said, "But I'm having trouble with this course in ethics." He said, "Look, son, just sit there. Look, I'm just a simple dry cleaner, but maybe I can help you. Ethics is this, my son. A man comes into the store with a shop with a suit of clothes. And he takes the suit, you give him his ticket, he leaves, and you reach in the pocket and you find a $100 bill. He said, ethics, my son, is deciding whether to share this with your partner." So what is the ethical responsibility at that moment in time when your client's place of business is filled with FBI agents? You've been a long-time counsel to this company. The agents are they're herding employees rather, into one room. And where do you draw the line? How do you go about doing this? And I think at that moment, Boris's advice really comes into play. I mean, you could take out the rules and take out 1.12 and this rule and that rule, but ultimately you have a responsibility to the moment. And my answer to the moment would be, I do represent the situation, and I'm going to sort this out. Now, as easy as that sounds, it comes with risk. And the risk is you'll make a mistake. And the mistake you might make in the moment is if you take on too much responsibility, at some point in time, you may find yourself kicked out of the case because you went too far, you talked to too many people, and you no longer can either represent the company, and you can no longer represent the chief executive who was in the next room. You know, if you saw that program, Billions, you know that program, Billions? And there's the moment when the agents come in the room and you try to imagine yourself in the room. The agents are running around, they're opening up drawers, they're talking to secretaries, they're talking to vice presidents. But you need to take command, and take command comes with risk, but nevertheless, trying to sort it out the best way you can.
So the next question, though, I want to ask, because when there's a raid going on, you got to act very quickly, and I'd like Sung-Hee and Charlie both to address this. Sung-Hee, suppose I call you as a prosecutor and I say, well, I'm the lawyer for the situation, or maybe I say I'm the lawyer for the company, and as the company counsel, I have the right to be there. Or I say the latter version, which a lot of people used to do, is I represent everybody. But what's going to happen is the minute I start doing if they let me in the room, I'm going to tell those people I'm not your lawyer. I've just said the opposite, right? So how do you handle my request to be present at the interviews? And I'm also curious, Charlie, what rule did Boris have in mind when he decided to represent the situation? Because I didn't know situations could pay bills.
To start, I guess I would say, Mr. Situation, we understand your interest in being present at all of the employee interviews, but as you know, you represent the company, and that does not necessarily mean that you represent all of the employees. And in fact, under Rule 4.2, you can't possibly represent all of the employees because Rule 4.2 is subject to other rules, including conflict of interest rules. So it depends on the particular facts and circumstances of each case, as all legal and ethical situations generally do. But depending on the jurisdiction, you may have a right to be present for those interviews of folks who are covered by 4.2. And different jurisdictions define who is covered in different ways. And so that's going to it's going to depend on the particular situation.
Well, for example, Florida's rule is anyone who has the authority to bind the corporation could be represented by counsel. And so I said, but I have no idea who's even there or in the room. So how do I communicate to you? So will you let me sit through the interviews or not?
Well, again, it would depend on the particular facts and circumstances, and I think you would have to make the case that the people whom you would like to whose interviews you'd like to sit in on do fit within that Florida bar rule.
Okay. Now, I'm not going to ask Sung-Hee specific questions about ethical. How they would resolve a specific ethical problem, because they are so fact dependent. But perhaps you could tell the group, because something I didn't know is there's something called the McDade Amendment, which makes federal prosecutors responsible for the ethical rules in the state where they practice. How does the DOJ deal with that?
Right. So for those of you unfamiliar with McDade, it was passed in 1998. And as Mark said, it essentially makes Department of Justice lawyers subject to the state bar rules in the states that they engage in the practice of law, just as those rules would apply to any other lawyer in that state. And in the wake of McDade, the Department of Justice being committed to the importance of making sure that its prosecutors do fulfill their professional responsibilities, created a separate office called the Professional Responsibility Advisory Office, or as everything in Washington has an acronym, so it's called PREO. And PREO's sole purpose is to advise Department of Justice attorneys on very difficult situations that are very fact and circumstance specific, so that they can comply with their professional obligations as attorneys and pursuant to the McDade Amendment.
So if I'm the lawyer for the situation or the company, can I call that department? Or how do I deal with it? Because I want to get in that room and sit there if my state has that particular rule. Do I have direct contact with them?
No. PREO is strictly an internal Department of Justice office, and it does not have really an interface with the public. I think in your situation, I would advise you to contact, if you haven't been able to work out the circumstance with the AUSA, typically, in my experience, back when I was in the AUSA in the 90s, was that my supervisor got a call. If the issue is something that really requires attention, probably the supervisor and the AUSA would consult PREO.
Cheryl, can I ask you a question? Because I know the SEC's approach obviously is differently. You don't initiate cases with a search warrant unless you're working with DOJ on something. So similar situation, you issue subpoenas or for some high-level corporate officers. I call up, I'm counsel for the company, and I ask you, what you're investigating, and then do you raise with me issues about multiple representations at that point? Like, for example, senior level people?
In the situation that you've just described, it sounds like you've made a phone call and you've asked for general information about the investigation.
Yes.
Typically where the issue arises is in testimony, for example, when counsel for the company wants to attend in addition to counsel for the individual, or counsel for the company wants to attend and says that counsel represents individuals in their capacity as lawyer for the company. Typically, the SEC will ask questions about that and want to know whether the lawyer represents those individuals as well in their individual capacity, and then will, in many instances, turn to that individual and tell them, ask them whether they've considered the potential the potential for conflict and whether they're comfortable with that. But typically, that's as far as it goes. I'm not aware of many instances in which the SEC has pushed the issue beyond that and said that counsel for the company, if they also say they represent the individual, can't be present.
No, but I'm talking about a situation, for example, where, let's say, a CEO or a general counsel, in a particular case I'm thinking of, has his or her own counsel. Mm-hmm. And I'm counsel for the company. They meet, in my example, the Florida rule that, anyone who
Right.
can speak or buy in the company. So I'm saying I, as counsel for the company, also
I see.
want to be present.
I think, hate to say it, but I think it depends. And I think that in most instances, again, the SEC would want to understand exactly what the nature of your representation was. I mean, I think the big issue here is you've got a situation where high-level executives do act on behalf of the company, but nevertheless, there still could be some sort of adversity in the relationship. And so, again, I think the SEC's particular question will be, is this person separately represented, and can we make sure that that person is comfortable with you asking these questions as opposed to us speaking directly to the person we know as their individual lawyer. I think they're going to have some discomfort with you calling up separately without lawyer for the individual there as well. And I think they're particularly going to want to make sure that the individual CEO or other executive is comfortable with and has specifically expressed that they're comfortable with you separately having that kind of a conversation.
Well, I'll give you a specific example where I had a general counsel of a company who initiated an investigation, was also subpoenaed, but he caused a voluntary disclosure to be made to the government. And I was told as counsel to the company that I could not attend the meeting. Is that unusual, or?
No, I can see under your fact pattern how you ended up with that result.
So, Ira, you are in-house general counsel. How do you deal with situations like, well, let's start with where your employees are being rounded up and you want somebody there to sit with them?
Yeah, it's actually a fascinating buildup that you've said, Mark, because Charlie's situation is different than the one you pose to Cheryl. If you've got the roundup going on, the situation is really trilateral. Does the company risk cooperation credit in the event that the investigation ultimately reveals an issue by virtue of an appropriate attempt not to obstruct but to insert counsel? And I think ultimately that's going to depend perhaps on the exigency of the moment. If the FBI is in the offices because the shredders are working, or if the FBI is in the office because the next bottle of Tylenol that goes off the assembly line may be tainted, I think the department, even after McDade, is going to be in stronger grounds in saying, sorry, we're going to play the obstruction card. Your lawyers are just going to have to sit on the sideline while we do what we have to do, and we'll sort out the rule of reason later. Contrast that with a situation where those exigencies don't exist. I think the department would be on weaker ground, and I like to have faith that the department is reasonable enough that it would recognize it's on weaker ground, and an AUSA or an AUSA supervisor would say to the FBI, counsel may be present. Whether the general counsel can be present or outside counsel for the company can be present for all interviews, that's an ethical dilemma on our side of the aisle. That is, the employees may not have identical interests among themselves or with the executive group. And I think that the grown challenge for the white-collar practitioner, and certainly the challenge for the in-house lawyer, is recognizing at the moment that we have to balance the ethics of who we're representing at the moment, along with the risk to the company of loss of cooperation credit. That's the first situation.
So let's supposing you're in the situation where you get an SEC subpoena, and you have your own counsel, but the company counsel wants to be there. What would your view be about that?
It's a variation on another saying. It would be ask but don't tell. That is, I would ask to have company counsel present because I would never want to be put in the situation where after the fact the company accused me of breaching privilege by virtue of their not being there to invoke it. I would not tell the SEC that I won't be interviewed absent the presence of the company's counsel. So it would be ask but don't tell.
Now let me just change the version a little bit here. The FBI or the SEC or anyone conducting the investigation, they tell you that we're looking at your CEO or CFO or general counsel. And you were the one who was called by the company in the first place by one of those people to come down and handle the situation. Should you have given that person an upjohn warning when you first talked to them? And if I did that, would I ever get called by you again?
Well, certainly I'd feel differently if it were me being looked at than if it were the other folks, because there's very little upward mobility in corporate America and once you become general counsel. So there are opportunities to be created there. But in all seriousness, the lawyer that take the conflict out. That is, I'm not calling you because I'm the subject or, God forbid, target of an investigation. I'm calling you because I want you to represent the CEO or the CFO. Frankly, my first week in this current job, I had to go shopping for counsel on an important matter. I called the lawyer of my choice. The lawyer said, is it for you, for an individual, or for the company? Now, that wasn't a particularly off-putting conversation, and it told me that the lawyer had their ethical chops, and my choice of counsel was correct. But that's a very coded upjohn conversation. Would I be put off on that phone call if the lawyer said, well, who do you want me to represent? Because if you want me to represent you, then I may be adverse to the company. If you want me to represent the company, I may be adverse to you. I don't know how off-putting I'd find that, but for a general counsel who hasn't spent close to 4 decades in this ethical milieu, they may find that off-putting.
So, and John, I don't mean to skip over you, because what role does the judiciary have in this process at this point, if any?
First, I want to let you all know that a strong argument can be made that I'm responsible for all of this. When I was, in 1988, I was the chief of appeals in the U.S. Attorney's Office in Brooklyn and wrote the losing brief to the Second Circuit in a case called United States versus Hamad, which is how, ethical rules really first became part of the landscape of the rules of engagement pre-indictment. The Second Circuit, in an odd series of rulings, said that the no contact rule, then it was DR 7104, now it's 4.2, actually operated to confer rights upon people in the pre-indictment setting. And then we had this history that culminated 10 years later in this Citizens Protection Act, right? That's what the McDade Amendment is. Joe McDade, many of you know this, was a member of Congress who got unsuccessfully prosecuted, unsuccessful from the government's point of view, for conducting the affairs of his office as a member of the House of Representatives through a pattern of racketeering activity. And you know this, you don't shoot someone like that in the foot. Once he was acquitted, he's the one who was responsible for this rule, that the statute that requires prosecutors to comply with all ethical rules, no matter how varied they may be, in any of the jurisdictions in which they act. And, you know, that was a controversial piece of legislation. There was even a 6-month period before it became effective, and everyone thought the Department of Justice could never do business, could never conduct investigations if all of its prosecutors had to comply with 4.2 in all of its iterations. You know, and in some places, we had a hypothetical earlier. In some places, the client, for purposes of the no contact rule, is any employee whose acts can be attributed to the corporation. So that goes right down to the guy on the loading dock. And everyone thought that, gee, how can investigations possibly be conducted? And instead of an effort in DOJ to undo the McDade and do the Citizens Protection Act, we got the Holder Memorandum. So the problem that was created by having the ethical rules, and in that 10-year period, sorry, I'll end this in a second, but I created this cottage industry by losing that case. Because in that period, once the organized bar learned that ethical rules might be able to plug holes that were left by substantive law, right? Remember the Williams case, the Supreme Court said there's no obligation by a prosecutor to present substantial exculpatory evidence to a grand jury. The attorney fee subpoenas were very controversial back then. And in the wake of Hamad, the organized bar promulgated ethical rules. Prosecutor can't serve a subpoena for attorney fee information without prior approval of the court. Prosecutor has to present substantial exculpatory evidence to the grand jury. This became this vehicle to alter the rules of engagement became quite a big thing. In any event, I think for our purposes here, the answer on the part of DOJ was not to undo that piece of legislation, but rather come up with a way in which company investigations could be conducted, notwithstanding the breadth of the restrictions that are imposed by bringing the no-contact rule into this setting. What was your question again?
I have no idea. All I know, I'm fascinated how you gave us all this work.
I think it was, what's the role of the court? And there is no role of the court. There's no case or controversy. And, unless you can figure out, I don't know what you're going to put on your caption if you want the court to get involved. I'm not shy about exercising the power. I've never been shy about exercising what I consider to be a broad authority of a federal district court, but I can't for the life of me figure out how you're going to get any of the hypotheticals that you've posited thus far into Article 3 territory, at least not yet. Once something happens and something's on our radar screen, then you're going to seek the relief that you think you're entitled to based on whatever violation you think has been committed. And then we'll screw it up for you somehow.
So let's move on to the internal investigation or defense stage. Okay, I'm conducting the internal investigation. I want to talk to various employees. I give them the upjohn warning that says I represent the company, not you. I do all that. Is there any limitation under the no contact rule with me talking to a person who doesn't have counsel? Or do I have to get that person counsel if he asks for it? Anybody want to
Is that a
start?
serious question? I mean, if somebody asks you for a lawyer, and you're going to say, well, sorry, you're on your own. I mean, you could say that, if you want a lawyer, you can have one, but we're not going to pay for a lawyer for you. you're a nice former employee of ours, right? Who stays, in that situation? And so, I mean, I think that, look, I've been with clients, and it's quite interesting that people, even in the most modest positions in companies, have a great kind of fealty, is that the right use of that word, to the organization that they work for. And they're puzzled. Sometimes you come in and represent an individual, and who are you, and why are you with me? I want the company lawyer. It's the company. That's the company is a comfort place for many employees in large companies, and so they're expecting you to do this. And you just said to this employee, "I'm not going to get you a lawyer." So then the employee says, "Well, okay, I got that, but how about if I hire a lawyer? And I understand that there's a gentleman who's about to become a private lawyer, used to be a federal judge. I would like to have him as my lawyer."
Trying to brown nose John?
He's doing a good job.
And you say to me, "Well, okay, you hadn't do it, but we're not going to pay for it." I mean, that's kind of the dilemma. And reality is, the company is going to make value judgments, and this kind of gets, I think, gets kind of iffy. But the value judgment that the company is making is whether or not, if I really turn this woman out, I turn this employee out on their own, I am going to lose out on the benefit of the feedback that I can get from the knowledge that employee has of the situation. And so there are value judgments being made here. If John referred to the person on the loading dock. Well, what does the loading dock guy? He can't really hurt us, so I don't have to get him a lawyer. Well, guess what? He was bringing in the illegal goods that caused the counterfeit goods that caused the problem that you have. I'm not sure I answer your question, but that's how I would go about analyzing it.
Well, I had a client, a major public company, that had a policy that during an internal investigation, the employees were not allowed to have personal counsel there. Do you think that's ethical?
Well, no. Is it ethical? So the employee comes in and you say, "Look, I want to interview you, Mary, John, whatever." Okay, great. Look, I want to have my lawyer present. No, you can't have your lawyer present. Well, you're fired. I mean, you could do that. I don't, depending on what the labor rules are. I'm not a labor lawyer in that sense, but somebody, if the employee says, "Look, I'm happy. I really want to help you. I really want to cooperate with you. I'll do anything you ask. Please get me a lawyer." And you say no. Well, then the employee has a choice. He or she can quit, or you can change your mind.
As an in-house counsel, how do you handle these situations? Do you get them a lawyer? Do you allow them to have
Get me a lawyer, pay for my lawyer, let my lawyer be here are three very different situations.
Exactly.
All right? Get me a lawyer is in some respects, I'm picking the lawyer. And I'm not sure that necessarily diffuses an aggressive interpretation of 4.2, depending on how a state's disciplinary system is set up. Pay for the lawyer. I agree with Charlie. That's the strategic question within a company. It's a philosophical matter. Am I more likely to engender goodwill with the employee and maintain an information flow with a more generous interpretation of indemnity provisions than a less generous indemnity philosophy? Let me have my own lawyer here that you're not paying for. Now I'm into a realm of confidentiality concerns. Do I want that lawyer to know the secrets of the company in conducting the internal investigation? And there, too, I think the balance is it really a matter of trade secret kind of protection that is a legitimate thing to protect, or is it just, I don't want my dirty laundry in the hands of some lawyer that I don't control? The former, I'd fight about. The latter, I think you're really stuck with the fact under 4.2 as it's interpreted by the majority of states right now with letting them bring their own lawyer into the room. And if that's going to chill your ability to get information, it's going to chill your ability to get information. What you can't let it do as a general counsel is impede the government's access to the individual. In that situation, you still have to deal with the walk or talk dilemma that corporations face for ensuring the cooperation takes place.
Now, I wanted to ask Cheryl a question. John, you mentioned a no contact rule, but this is a different no contact rule. Could you talk about the KBR decision?
Sure. So just to start, there's a provision in Dodd-Frank that I'll just read. It says, "No person may take any action to impede an individual from communication directly with the Commission staff about a possible securities law violation, including enforcing or threatening to enforce a confidentiality agreement with respect to such communications." So in KBR, the SEC became aware that KBR did have a confidentiality arrangement with individuals that basically said that individuals were not allowed to discuss the content or the subject of an internal investigation, and basically gave the company the ability to discipline or even terminate employment of people who didn't abide by this written confidentiality agreement. There's no evidence that anyone at KBR was disciplined or that there was any allegation of a violation of the confidentiality agreement. But nevertheless, when the SEC became aware of it, it took the position that this was a direct violation of this provision of Dodd-Frank and imposed a cease and desist order and about $130,000 fine on KBR. So it leads to a couple of questions, one of which is, under what circumstances can a company tell employees that they cannot discuss the contents of an internal investigation, and in which circumstances would that be viewed as a violation of Dodd-Frank? I know that standard Upjohn warnings, for example, will say, clearly this is a privileged communication, this privilege belongs to the company, and also we ask that you keep the contents of our communication confidential. I don't think that this is enough to constitute a violation of this provision, but I know that people have certainly been asking that question.
So the question, what's sort of emerging here is, what do you do when your ethical obligations are bumping up against a rule like the no contact rule? Like the example you just raised is, because what was interesting in KBR is the questions that the SEC wanted to know is what the investigators were asking during the interviews, not the underlying facts of what happened. And so how do I resolve that as a lawyer? I mean, I am I just gave them the Upjohn warnings. I told the company, I told him it's privileged. The company holds the privilege, and yet the SEC or that particular case conflicts with my obligations. Or what do I do?
Well, I think you're in a tough spot. I think what the SEC is really trying to do here is ensure that there's nothing that impedes an employee's ability to go to the SEC and tell them specifically about potential misconduct. Now, that doesn't necessarily mean telling them about the contents of a particular interview so much as being able to tell them about something they think might have been a violation of the law. And I think that there's a fine line between telling people that they can't talk about the contents of an interview and telling them that they can't go to the SEC at all about the whole subject matter that might be under investigation.
Right, but again, with the context of KBR, though, the issue was what did the investigators ask?
Right.
Which I think. I'm not sure it was rightly decided, but it was settled with a consent order.
It was a consent order, for sure. And I think that it's an interesting case, but I wouldn't anticipate there'd be a lot more like it, and I think it's fairly unusual. And I don't think that for the most part, it's something the SEC would even become aware of, that there was this sort of an arrangement or some sort of a requirement that people keep this confidential. I know they're clearly aware of the language, the Upjohn language, and they know that in general, employees are being asked not to talk about the contents of investigation. I've never heard of them raising an issue about that.
So let me ask you another, and anybody feel free to answer this, but because it's happened to me. I'm doing an internal investigation. There's a sealed key tam, right? Sealed what? Key tam, a False Claims Act case that's filed on behalf of the government. Does everyone know what a key tam is? It's a False Claims Act that a private person can file on behalf of the government. It is sealed. The person who files it is known as a relator. and if the government intervenes or he pursues it, he will share in the recovery. But it has to be a False Claims Act type case. So I'm now doing my internal investigation. Can I ask and whether he is a relator? And if you were his counsel, what would you say that he should? How should he respond? I'm going to ask you first.
I'm not aware of any ethical rule that would prevent you from asking that question.
Right.
I don't know what ethical rule would prevent the, and what would govern the counsel for that relator. But I'm not, from the DOJ's perspective, I don't think there's any way to prevent you from asking the question.
Yeah, but the problem, as I see it, is that on the and Charlie, maybe I'll direct this to you, but I'm telling you in the Upjohn warning, right, that I may turn everything over to the government, and I want you to be truthful, and I ask the question. So, what happens? What do you advise your client now?
So
is the relator?
my client is the relator?
The relator.
Okay, so he has three choices. Choice number one, he could take a civilized version of the fifth and say, I'm not going to answer your question. Right? Choice number two, he could give you the truthful answer. And choice number three, he can lie. I guess there's a fourth, he could walk out, which is the same as two, I guess.
Well, but
I don't think there's
the
any...
truthful answer, though, would violate the sealing order.
Oh, well, who's going to enforce the sealing order? Who's going to enforce that? I mean, I get the question, but I mean, there's a reality to the moment, and I'm sorry, I wasn't talking to the microphone. The reality of the moment, it seems to me, is that it seems to me it's appropriate for you to ask the question, unless you know, perhaps you know about the order, and maybe you're the one, by asking the question and violating the order by putting me in a position where I might have to answer the question.
There was a time in the early and mid '90s where the department. The civil division of the department took the position that it's not a legitimate question for counsel to inquire who's the relator. That is, until a key TAM action is unsealed, at which time the relator is revealed, it's subject to a sealing order. The department is conducting a parallel investigation, and the legitimacy of the inquiry into are you a relator, because you suspect there's a relator out there because there's been a document demand from the government. Number of defense procurement cases in the early and mid 90s, the department took the position that's almost an obstruction of justice. Personally, I don't care if you're a relator or not. As a general counsel, I don't care if you've complained or not. Dodd-Frank tells me I can't retaliate against you if you have. What I want is the information. I want the underlying facts. Now, by the same token, I think KBR is wrongly decided because intruding into the company's work product, what questions were asked, is not a legitimate inquiry by the government. What facts do you have about the underlying events? That's the legitimate inquiry by the government. We should do nothing as in-house counsel to interfere with that if we want the cooperation credit. Indeed, we should encourage that. But the work product of my lawyers, for which I pay dearly, and how it is they conduct their investigation, the questions they ask, I don't think that's fair game, unless we're going to change the rules of evidence and allow me to have a conversation with the government that truly is privileged from civil whistleblower cases, from derivative cases, as I'm able to have with my regulators, because there are state laws that protect those communications. But absent a protection for the communication with the government of my work product, I don't think my work product should be fair game.
But
Yeah.
just a quibble, I mean, don't you want to know who that relator is? I mean, you want to know what employee of the company is ratting you out, for goodness sake.
You know, there's a world of want and then there's a world of need. And I want to be thin and rich. It's not going to work out for me in this lifetime. What I need is to live a few more years and enjoy life. I really do think you don't get, in the balance that we've achieved in the back and forth over these ethical situations, there are things that are fair game for us, and there are things that are fair game for the government. And I just don't see asking a suspected relator, are you the guy, to give the impression that I'm asking, are you a rat? It's not good for the image of the company, and so it's not fair game.
All right, so let me ask the panel, can the government ever ask you to refrain from interviewing one of your own employees or keeping that person employed for a period of time?
Can they or should they?
Well, should they?
Should they? Again, I think it's going to depend on the exigency of the situation. If there's a need for them to get at the information that's more important than the need for me to get at it to clean it up, yeah, I would accept that request by the government. As a matter of course, because the government doesn't trust the internal apparatus, I have a little bit harder time dealing with that.
And in terms of asking you not to terminate an employee, I think clearly, if you think that this is an employee who's in a position where they can do more harm, then you're going to have to think about that. Employing them doesn't mean employing them the same way they were employed before. But typically what they'll do is they'll ask you that because they want to be able to use the company's leverage to be able to reach out and talk to that person themselves. And it's usually for a fairly limited period of time. So a fairly standard request.
Well, that happens a lot in the FCPA arena where they want witnesses to come in from overseas or stuff.
Right.
But I just want to add, though, that when those requests are made, we are very open to working out with the company, because there are every situation is different, and we are mindful of the company's need in some circumstances to limit the particular employee's responsibilities if that employee has been identified as somebody who is culpable or who's potentially engaged in wrongdoing. So I don't want you to get the feeling that we would willy-nilly always expect that the company refrain from interviewing or refrain from terminating the employee. We would like to have a dialogue with the company and company counsel to make sure that both the government and the company's interests are satisfied. And generally, I'm not aware of any particular circumstances in my year-and-a-half stint in the criminal division where that's presented a problem.
Well, but what about my duty as counsel to the company to find out what happened and to rectify it and to actually eliminate the potential for an employee continuing to cause harm? Don't I have an ethical obligation to talk to that person, find out what's going on, report it to the company?
Well, that's precisely why we try to engage in a dialogue with you, and hopefully you and I, or whoever the trial attorneys in the fraud section or some other section of the criminal division, would have that conversation and try to work that out.
There is this line between ethics and strategy and ethics and law, and I mean, seriously, in kind of preparing for today, I really began to think a lot about this, and I don't think this is an ethical issue so much as it is a strategic issue, because I don't see where your ethical responsibility comes into play here, Mark, but I do see that there is an interesting strategy in terms of you being able to represent your client on a going forward basis.
Actually, Charlie, I'll have the small quibble. I think it's where the ethics meets the strategy. I have an ethical obligation, as Mark says, to get to the bottom of, are you messing up today? And do I have something I need to cure today? I have that ethical obligation to my client. The strategic choice is, would I rather have the cooperation credit than fulfill the obligation to the shareholders to stop the conduct that I suspect is ongoing today. And that's a subject for negotiation, begging, groveling, whatever it takes to deal with the government to preserve your ability to get the cooperation credit while still obtaining the ability to stop the bleeding. That's where the strategy meets the ethics, I think.
John, you had talked about this morning when we were preparing the differences in rights between an employee who has counsel and one who doesn't. So could you explain that a little bit?
Well, to the extent that these ethical rules, the rules that bind lawyers, pertain to, afford protections to people who themselves have lawyers. This goes back to Hamad, really. I've been stewing in my juices over this case for 28 years. But, the oddity of viewing ethical rules as something other than ways to police the ethics of the profession, and to view them as a source of rights for people I've never lost sight of how odd that is, because what you end up doing, all the other rights that folks have in an investigative setting are rights that everybody has. But the minute you inject ethical rules in as a source of rights, then you're affording rights only to the people who happen to have counsel, which is weird, especially since they're the ones who need the protection the least because they have a good lawyer telling them to keep quiet. Always struck me as odd that ethical rules would become a source of rights only for some people out there. And the flip side to the oddity is, whereas all rights tend to be enjoyed as against the government writ large, once the source of rights is in the ethical rules, then the rights that are enjoyed only as against part of the government, the ones who happen to be lawyers, right? You create this bizarre incentive to cut the lawyers out of the investigation, because if the ethical rules constrict the rules of engagement, well, just leave it up to the FBI agent and don't have as an impediment to gathering information the scope of Rule 4.2, because that's only a right that someone has as against the lawyers in the government. In any event, this is all, I don't purport to be an expert on this, but for the fact that I teach it, I'm a sitting judge. I don't have much exposure to this. That's changed a little bit with the use of these DPAs, with the filing of charging instrument. But for the most part, I've been sitting around watching this from a distance because all of this doesn't make it onto our radar screen. I don't know if that came close to answering your question.
Can I ask you this, John? I mean, we talked a little bit this morning about the difference between the FBI agent basically, right, can walk in and conduct an interview of a represented person. He's not a lawyer, a represented person. He sits down, she sits down, and she interviews the person. So the issue to me is where the relationship between the FBI agent and the Assistant United States Attorney, the Assistant Attorney General, how do they interplay with each other, and how much does the lawyer know what the non-lawyer is doing to further the investigation to try to put people in jail or put people out of business?
Well, to the extent there's law on this, and Hamad, for a lot of reasons, has kind of become a bug in amber, but I think to the extent there's law on it, it suggests that if the lawyer in the government, the prosecutor, is aware that the agent is out there knocking on the door, that converts the agent into the alter ego, to use the phrase from some of the cases, of the prosecutor. So you can't do indirectly what you're prohibited from doing directly. That's why this model, a model that allows ethical rules to become a source of rights, has this pernicious effect of giving the government an incentive to keep the lawyers, who presumably are in the best position to know what people's rights are, best position to make sure they're not violated, the targets of investigation, creates this bizarre incentive to keep the lawyers out of the room entirely. It keeps an incentive for agents not to even tell Sung-Hee that they're going out to knock on the door of the employee.
At the risk of quibbling with a sitting judge, there is case law.
We have one more week.
Yes. There is case law to the effect that agents, even under the supervision of a prosecutor, may interview represented persons pre-charging. So that, again, as I said from the outset, it depends on the facts and circumstances of each case. It depends on the particular jurisdiction and the like. But there are cases out there that say that even under the scenario you presented, that the agents can interview represented persons at the pre-indictment or pre-charging stage.
And that's absolutely right. And Ryan's, a bunch of cases made Hamad an outlier. All of those are now a bug in amber because now, because of the Citizens Protection Act, there might be, if the agent is working with the prosecutor, there might be a 4.2 problem, notwithstanding Ryan's and those other cases that disagreed with Hamad, precisely because we have the Citizens Protection Act.
And in any event, the remedy is going to be suppression of the statement if it does in fact create a right. The prosecutor is still at risk then of an action in the State Disciplinary Commission. And so as a defense lawyer at the time, I opposed McDade. I oppose McDade now because I'd rather have the prosecutors in the mix looking for a balance in the situation than leaving it in the hands of the FBI or the DEA or whichever agency it's going to be. And some of my best friends are FBI agents, but that's not the point. The point is, who do you want making the decisions on the other side of the table? And I'd prefer it be a lawyer looking for balance than an FBI agent looking for a result.
Well, let's modify the facts a little bit. Let's supposing the government is actually conducting an undercover investigation, and you, as a lawyer to an individual, you get the sense something's up. So you call the AUSA or you call the U.S. Attorney's Office and say, look, I am his lawyer. All future communications with this person have to go through me. How does the government or Charlie, how do you respond?
Well, having made the phone call, I mean, I think I would be rather, I want to use the polite word, I'd be rather starting with a P and ending with a D with letters in between. I'd be pissed about that. I mean, how could you allow that to happen? Now, this is where I will confess potentially some ignorance as to whether you could do that or not, but it is inconceivable to me that if I made that call to a federal prosecutor, said, look, I represent Jane Smith, and I'm telling you, you cannot have any of your agents or anyone else talk to her unless I'm present. To me, that should be a no-brainer. No?
It's not a no-brainer. Sorry. Again, it depends on the facts and circumstances, and it depends on the specific jurisdiction. But generally, most courts have held that even represented persons can be approached. There can be communications by the agents at the pre-indictment stage. So covert investigations, which this would be, right, because it's an undercover investigation, almost all the courts that have considered the issue have held that it is proper for the investigation to continue, and that you as counsel to that particular individual can make the request, but that, again, subject to the prosecutor's own ethical obligations in terms of the professional responsibility rules that apply to him or her, that generally the authorized by law carve-out under 4.2 allow these covert investigations.
Why shouldn't this ethical concept, why does it have to be a concept from state to state? Why? If it's in Iowa.
That's the reason why McDade should never have been passed,
well,
maybe.
But if it's in Iowa, it's okay to do it. If it's in California, it's not okay to do it. I mean, it seems to me that we ought to get our act together as lawyers. If we have a standard of ethical rules that govern our conduct, then they should be national rules, not rules from state to state. Because I heard the Assistant Attorney General this morning talk about how broad investigations are. They're all over, not only they're all over the world, but now they're certainly all over the United States. And so it puzzles me, and I recognize, what you're all saying, but I don't find it acceptable.
I think it goes back to what John was saying earlier, that it's resulted in some collateral consequences that may never have been intended.
Right. Well, it's DOJ's fault for indicting Joe McDade and not convicting him.
That preceded my time, so.
And I actually think this whole cottage industry, from Holder to Thompson, McNulty, all of that arises out of a need to avoid the potential disastrous consequences of the Citizens Protection Act. Right? This is, so use company counsel to do the things that are now ethically dubious because of this patchwork quilt of ethical restrictions. And once you deputize, however you want to characterize it, once you deputize company counsel to do the work that you might be constrained from doing yourself, that's what we have. That's why we have so many of these conferences.
And it's not just the fact that we have 50 different sets of rules to deal with post-McDade. The concept of situational ethics isn't simply a matter of geography. It will ultimately, in the hands of state bar authorities, and I speak to those folks with some frequency, not because they're beefs on me, but because I interact with them socially. There haven't been beefs on me in years. One of them actually over these very issues, but situationally, isn't it really going to depend on the exigency? If Charlie calls the prosecutor and says, stop contact with my client, and there's a Title III up where there's been a warrant signed by a federal judge, very few bar authorities, I think, are going to go so far as to call an assistant U.S. attorney or a fraud section lawyer to account for his or her license by virtue of continuing that Title III for however long the federal judge lets it stay up. Whether the assistant has an obligation to disclose Charlie's call, that may be an area of situational problem for the assistant that is disclosed to the federal judge on the next application. If there's an ongoing crime that's being investigated by the undercover operation, that situation may, not necessarily, but may be viewed differently by bar authorities than if the undercover operation has, for want of a better phrase, come a cropper at that point. So if there is no evidence of criminality at the moment that Charlie makes his call, the prosecutor may be taking more of a chance, depending on the state bar's interpretation of 4.2, than if the investigation has revealed substantial criminality to that point. So I think simply because McDade is out there, simply because people are following a model 4.2, doesn't mean the bar authorities in Oklahoma are going to interpret their version of 4.2 in the same way as the bar authorities in Illinois or New York or California or Florida are going to interpret 4.2. And I'm willing to bet, because betting's legal in the state I work in now, that, but I'd only do it in the state I'm in. I'd be willing to bet that those same bar authorities in Oklahoma are going to view Charlie's call differently if he represents Timothy McVeigh in the middle of an undercover operation to determine did he blow up a building with federal officials in it, than if he calls up because he represents a business person who is adding an inappropriate amount of filler to ground beef. So again, I think there's going to be situational judgments throughout that process, and we just have to be aware that this organization, that is the ABA white collar group, as much as any, supported McDade. We have, collectively as defense lawyers, interjected the concept of 4.2 creating defendant rights. Well, it's those situational dilemmas and the department's candidly understandable effort to rebalance what we have balanced or unbalanced, depending on your perspective, that we are dealing with situational ethics in this arena.
So let me change gears a little bit. Given the Yates Memorandum and the newest version of the U.S. Attorney's Manual, what is the future of joint defense agreements between a company and people representing individuals at the company. And I'm going to start with Ira.
What joint defense agreement? We talked about this earlier. I mean, I come from a prosecutive background when it was okay to say we don't like joint defense agreements. The department went away from that when Bob Mueller, as assistant AG for the criminal division, opened up a dialogue with this group. But in his heart, he still disliked joint defense agreements. As a defense lawyer, I think Bob came to the view that joint defense agreements had their utility. I think in a post-Thompson world, so 25 years ago, not a post-Yates world, general counsels had to consider what's the strategic consequence vis-a-vis protecting the corporate franchise in its negotiations with any government oversight, whether it be a regulated business or the department or the SEC, against the utility of gaining information. Because the idea of being friendly to corporate executives got thrown out the window by Larry. Now, I don't think that that was necessarily a bad decision, but that's the reality, and that's not something we can blame Yates for. It's not something we can blame Eric for, or the Phillip memo, or maybe we can blame McNulty, but that's for different reasons. It really goes back to a fundamental determination by the department that joint defense agreements, not so good. And if you think about it, joint defense agreements arise from the concept of mutual interest. At the end of the day, the corporation has a single interest, generating money for shareholders legally. And if gaining information from individuals requires a mutual interest arrangement in order to preserve that ability, general counsel is going to sign off on it. If a mutual interest is outweighed by jeopardy to the company's ability to secure cooperation credit, we're not.
Well, I think the Yates memorandum makes it pretty clear that you have to disclose all relevant facts. And so you might be obtaining some of that through a joint defense conversation. And that puts you in a, I think, more difficult position, whether to weigh the common interest privilege with your ability to obtain cooperation credit.
In now 10 years as a general counsel, I haven't signed a joint defense agreement, and I've lived through an awful lot of internal investigations. So it is possible to get information. It's not pretty. The concept of walk or talk is a brutal one to inject into the C-suite, but it is nonetheless possible to get the information that the company is entitled to if the board's willing to stand up for it, and frankly, post-Caremark, the board has no choice.
Now, the SEC hasn't come out and made the same statement. So, Cheryl, I'd like you to get your view from as a former SEC lawyer and now as a defense lawyer, how you feel about joint defense agreements in an SEC investigation.
You're right. The SEC's not come out and spoken out against joint defense arrangements, and I think it's unlikely that it will. One of the things people have asked is whether the SEC will take a similar approach to what we're hearing from the Department of Justice as it relates to scrutinizing more closely the relationship between the company and individuals, and the sort of the incentive to think hard about individual culpability and making sure that all relevant information about that is being shared with the government as early on as possible. I think that the mindset of people who do this kind of work is that was always the case, that there was an expectation that you would do that. Joint defense arrangements are something that the government may ask about. They clearly in some investigations have asked whether that, whether there are such arrangements. And I think you need to think about what the appearance will be if you tell them that you do have those, particularly if you are aware pretty early on that they've set their sights on some of these individuals that you've determined that you're going to enter into these arrangements with. So, on the margins, I would say, things are the same as they were before, but one of the things that happens now is that we think more carefully earlier on about whether it really makes sense under those circumstances, given what we know at that point, to enter into them, particularly with individuals where we think there's a potential issue or potential keen interest in the government and perhaps pursuing a separate case against those individuals, particularly the executives at the company.
Can I just add that before rejoining DOJ, I spent 15 years representing both companies and individuals, and in my experience, virtually all of the companies I represented, this is way pre-Yates, for the reasons that Ira mentioned, almost never entered into a JDA, whereas the individual, when I represented individuals, we always wanted JDAs. I don't think Yates has changed that at all, and in my experience, maybe I don't have the perspective of being the general counsel, but when I represented as outside counsel the company, we almost always were able to get the information that we needed from the individual employees without a joint defense agreement, because it was seen by the employee, his or her counsel, if in those situations, and by the company. It was seen as in everyone's mutual interest for the employee to provide the information to the company. So I think it may be sometimes at the margins a little bit more difficult for the company to get and company counsel to get some information, but for the most part, I don't think any company counsel has had really that much difficulty getting the information they need without a joint defense agreement.
Well,
So Charles,
some of it comes under, there's the new rubric of calling it common interest, instead of, because joint defense agreement just has created this very terrible, atmosphere. And when I hear you say 15 years ago, I mean, I did those agreements. It has a 5 in it as well, but my number has a 5 in it, but has a different number in back of it rather than in front of it. And so we had joint defense agreements. I was at tons of meetings with Barry Bohr over there. Where's Naftalis? And we were at meetings like this all the time, and I never really felt there was anything wrong with it. Although there's a line in one of the circuit opinions in the Stein case. Stein, is the KPMG case, and the court said it is unclear how circling the wagons is much different from legitimate melding of a joint defense. Again, my daughter once said, my dad, she was 16, she worked for us one summer, she said, my dad has the best job. And said, why is that? He said to my wife, well, he spends half of his day on the phone talking to his friends and the other half of the day meeting with them. And so there was really nothing bad about it. I don't know exactly what happened to the attitude reflected by law enforcement to what was a kind of a sound strategic way to deal with the situation. And I recognize that, it's different with the corporation, and you're totally right, that when individuals got together, I don't think government really got that upset about it, or, obviously got upset because it may get in the way of investigations. And companies on their own began to back away from joint defense before all of these, rules set out by various deputy attorney generals as they assumed the job. So, I mean, as I say, I know there's a great deal of tension about it, but I think the tension is somewhat unnecessary.
But Charlie, if I'm, again, counsel for the company, and I want to talk to your client, and this company allows you to, or doesn't enforce any kind of internal policy against a person having a lawyer there, what are you going to insist that there be a joint defense agreement to allow your client to talk to me?
Am I going to insist that we have a...
Me as company counsel and you as counsel for the individual.
Hey, listen, if you want to dance with me and be in a joint defense and you're the company and you're paying the fees, I'm perfectly happy to enter into that agreement. But
I'm saying,
one more sentence,
but take Ira's example that he wouldn't do it.
Well,
what do you...
Look, but Ira's representing the company. He has a totally different client. He has a totally different set of responsibilities. My job is this one human being that has put their faith and confidence in my ability to take them through, this sea of trouble that they're in, that could wind up at the end of their lives, with guidelines. And, if you do this major crime, you're going to get 20 years in federal prison. That's my responsibility. And if getting together with you in a joint defense works for me, I'm a little leery now because of the fact that you want to make sure that you're good to the Yates memo and you're watching Yates. I have to be careful about that. But to just simply say no, to me makes no sense at all.
Well, I was actually asking whether you as counsel for the person would want that protection in some way.
Well,
during an internal investigation, for example.
But the problem is, sure, I'd like the protection, but I know that you have different responsibilities. And I know that you're just worried about the fact that they're going to close the doors of your corporation.
Right.
And so I'm very leery of entering into the agreement with you.
No, but what do you do? Do you tell your client? Let's supposing it's a person who may have some culpability, but you're in an early stage, you don't know. Do you tell the client, don't speak unless there's a joint defense agreement?
I mean, you want to interview my client.
Yes.
You want to interview him or her, and you want me to agree to that.
Yes.
Well, obviously, I first have to know the facts. I mean, if the facts are, if what the client is going to disclose is going to put him or her behind the 8 ball, I have to figure out a way to dance around that because, again, we have different responsibilities in the moment, Mark.
But in that moment, Charlie, when I call you and say, I'm delighted that you're representing the CFO. CFO, from what I see, needs a good lawyer. I need the information. You can talk to your client for the next 24 hours, and you can produce him to the company's outside counsel who's going to conduct the interview, or we're going to do an SEC disclosure that we've replaced our CFO. That's really where I have to be if I'm going to be able to defend the company and obtain the ultimate result. Put the department and the SEC aside. I'm a regulated business. As a regulated business, I have to live wholly transparent to my regulator. I get that nice protection for what I tell them, but I have to be wholly transparent and I have to be wholly clean. We've got affiliation rules that make good citizenship not a laudable goal, but a requirement. What do we do in that circumstance? You and I will still be friends, but your client's got a dilemma.
Well, can I just ask you a preliminary question? Are you going to pay the fees?
Absolutely. Your client, for the CFO is entitled to indemnity and advancement under our bylaws. Look. Now, you're going to have to sign an undertaking, which is that if your client is convicted of wrongdoing, you're going to pay us the money back. Now, if your client turns out to be a turnip, I'm not going to get that money back. But if your client is sitting on top of $20 or $30 million worth of stock options, I'm going to get that money back.
Look, life has reality. If the client has genuine exposure, if speaking to you and speaking under any of these circumstances is going to put the client in a jackpot, then the answer is they can't talk to you. It's not more complicated than that.
So, but you also have the fact that for many of these executives, they've got an employment agreement where they basically are obligated to cooperate with an investigation, right? And I think that's part of the context, too.
Absolutely. And in that circumstance, one has to hope that the regulator, the investigating body, if it's a state AG or the department or the SEC, is going to understand that while they would have liked you to hold on to that executive, you just can't do it. You're going to have to let that executive go the way of the mastodon.
One of the issues, Ira, you mentioned is you're in a regulated industry, so it might be a little different. But there's a case, of course it's KBR again, but in Reg KBR, Kellogg Brown & Root at 756 F3rd 754, where they, as a defense contractor, were mandated to conduct an internal investigation and make disclosures. But the court also held, even though that was mandated, their right to maintain their attorney-client privilege and work product remained. So,
Again, the situation that the in-house counsel find themselves in today is, first and foremost, you protect the franchise. If you're regulated, you protect the license. If you're a government contractor, you preserve the ability to participate in government contracts. And the only way that that can be achieved practically is, Charlie, I need the CFO to talk. And by the way, Charlie, if you want to be in the room and you're a stranger, that is, I don't know you, I don't know that I can trust you, I'd like to have you sign an NDA, not for purposes of protecting the confidentiality of my upjohned interview, but for purposes of protecting my trade secrets.
Look, can I, last point I want to make on this subject about whether you allow the interview. So I represented a CFO of a public company, and there was an investigation, and my client spoke to the lawyer for the company who was doing the internal investigation. Well, fortunately, I can say I was not his lawyer at the time because I was not responsible for the fact that at his trial, when he went to defend himself against the charges, one of the worst witnesses against him was the lawyer that conducted the internal investigation. So life has reality.
No, and for those of us who have conducted internal investigations, the absolute worst experience there is testifying against those executives or employees that you have interviewed in that circumstance. But again, it's part of the corporate compact that exists today.
I wanted to move to an area that John had suggested, and you had mentioned before that the role of the court at least is limited to maybe not even participating pre-filing of a charge, but we've seen now a growth in the use of DPAs, and basically what the government is asking you to do is defer prosecution and until for X number of months or years, but there's a filed charge now. So what role does the judiciary have during the period of suspending the prosecution?
Good question, and the answer to it's still up in the air. And my exposure to this is largely this HSBC case, which is a pending case with a pending motion. So I'm just going to tell you what's a matter of public record on it. And by way of backdrop, one way to put the question is, what's the scope of a court's authority over a deferred prosecution agreement while it's during the pendency of the deferred prosecution contract? And by way of backdrop, in part as a result of some of the stuff we've been discussing today, I wrote a law review article a long time ago, was on the bench, about what I thought was an overuse of the supervisory power of the court. There was that Hamad case. There was a case in the Second Circuit called Ming-Hee where the court decided, pursuant to its supervisory power, the Second Circuit, that it's supervisory power over criminal prosecutions, that lawyers for cooperating, this was Leslie's case, I think. It's Leslie Caldwell's case, that there was a right for cooperating lawyers to be present during the debriefings. Of course, it's a right that, like, overnight got contracted out of existence in the cooperation agreement. But the point is, I thought then, and I said it, that judges need to be really careful about whipping out this supervisory power. And there's some Supreme Court precedent on how narrow that power is. That Williams case I mentioned earlier, Justice Scalia wrote an opinion for the court saying you can't have pursuant to the supervisory power of the court, you can't dictate a rule that prosecutors need to present substantial exculpatory evidence to a grand jury. Anyway, the point is, I came to this issue from a perspective of respecting the reality of institutional disabilities, and you don't know nothing when you're a judge, really. about things like cooperation and striking deals and the like. All right, so to get to the point, I've been watching this stuff from a distance and teaching it, and most of my exposure to it was talking to people at meetings like this about like non-prosecution agreements, which never make it onto our radar screen. And then in comes HSBC, and a 5-year or deferred prosecution agreement is presented to me. An information is filed. The company waives its right to grand jury indictment, and the government basically says to me, along with HSBC, that my job and my only job and the only power I have over the case is to order an exclusion, a 5-year exclusion from the Speedy Trial Act. And my sense of it, some of the cases I teach include KPMG and things that happen in the course of these types of investigations. I take to heart the fact that once a matter is put into the third branch's territory, once something's filed and it's on a court's radar screen, that I concluded that the court has more authority in that setting than the government and HSB said that I had. So I held that the supervisory power of the court embraces a responsibility to protect the institutional interest of an Article III court, so that if there were improper things happening in connection with this deferred prosecution agreement, I would have the authority to monitor it and correct it. I think there's a couple of issues. One is whether that's right. A couple of courts have followed my lead in that regard, and there's a Fokker case that Judge Leon in the D.C. District Court wrote an opinion that accepted the notion that there's a supervisory power-based role for a court, and then he rejected the agreement. And I think there's really two very important issues that are yet to be decided. One is whether I'm right, and I know I think it's under submission now. I think it's been argued. The Fokker case has been argued in the D.C. Circuit. I've been appealed in HSBC, albeit in a slightly different context. And at some point, we'll get a definitive statement, I suppose, of whether there's an ambit of authority for a district court over a deferred prosecution agreement. The second question, I think, is really more important, and that is, assuming there is authority, what's the degree of deference that ought to be accorded the parties' agreement? And although I reserve for myself a responsibility, the authority to continue to monitor the ongoing deferred prosecution relationship, thus far I've approved it. I've approved the deferred prosecution agreement and that's by contrast, Judge Leon didn't. So to my mind, and at least an equally important question about a question that's as important as whether there's authority is, assuming there is, how much deference ought to be paid to the agreement. And you can read opinions yourself. Jed Rakoff has a view about deference to agreements reached between the government and entities that the government interacts with. I expressed my view, which is a kind of a broad deference, recognizing a court's institutional limitations when it comes to second-guessing those agreements. I think it's fair to say, just from reading our opinions, that Judge Leon has a slightly less deferential view. So that, if there is authority at all, then a very important question is going to be how much deference must be paid, and all that's still up in the air.
Well, one of the things that's happened, though, right, is you now have a filed charge, but you're really deferring to the government to make a decision about what's going to happen to that corporation, or maybe even the individuals. Can I go to you during dependency of a DPA and say, look, I don't think either the monitor or the investigating attorneys are treating my client right, or do I have no ability to do that?
Well, one of the things expressly contemplated in my written decision is the notion that a situation like the government conduct in KPMG might come to pass in connection with the 5-year course of conduct under this deferred prosecution agreement, and without holding anything, in that regard, or so that's a possible event in any case like that would be someone coming into the court before whom this deferred prosecution, this DPA agreement and the related information has been assigned, someone coming in and saying, look, this is now in your ballpark, it's on your radar screen. You have lent there's a judicial imprimatur onto this arrangement that doesn't exist when it comes to a non-prosecution agreement. I mean, I assume there's a reason DOJ didn't just make it a non-prosecution agreement. They filed an instrument. There's some value added from DOJ's perspective to have a pending case against HSBC. My sense of it, right or wrong, was, okay, fine, but now you're in my house. And I have to vindicate the interest of the judiciary. So I can't, there's a couple of other scenarios, hypotheticals that I mentioned in the agreement. What if the U.S. attorney decides, as part of this deferred prosecution agreement, that the company is going to endow a chair at the U.S. attorney's alma mater? Hypothetical case. How does it look that this has the apparent imprimatur of the court because they've placed this agreement in front of me and they placed their dispute in front of me and there's a pending criminal case? I obviously believe that there's how this would work out in particular settings where someone would come to the court and complain is yet to be determined. But I think there's an institutional responsibility on the part of the court that needs to be exercised, and it would get litigated. But yes, now you would have, unlike what we talked about earlier, now you would have a caption for the document you would file. It would be under U.S. versus HSBC. You'd come in, who knows what would happen, but now you have a case or controversy within which to make your beef.
So I suppose, does the question become when we come back, was it in Florida next year, there will be a panel that will be discussing what happened to deferred prosecution agreements, and they all became non-prosecution agreements.
Right.
Sung-Hee, do you have a view on this? Or?
Well, as John mentioned, both cases are pending, so I'm limited in what I can say beyond what's in our public filings. But when one of the biggest themes in both cases that in the government's filings is that there really is a constitutional separation of powers. As John has come out in one way in terms of what the scope of the court's authority is, and also the degree of deference to the executive branch. Other courts have come out at the other end of the spectrum, or at least slightly differently. And so where do you draw the line? Once you have the court sort of second-guessing the parties, which are in these agreements that are reached at arm's length. I know, Mark, you've mentioned the prospect of an ongoing DPA where the company has some beef with the government and wants to bring the court into the process. That just opens the door for what if there's a perceived violation that the government believes has occurred, and the government, I'm just speaking hypothetically, the government wants to address that potential violation or breach in one way, but the court second guesses you and wants to impose a higher penalty for that breach. Do we or you, as lawyers on both sides of the aisle who hopefully have come together and reached a negotiated arm's length agreement. Do we really want courts with very little consensus as to the scope of its authority and the scope of the deference that it will accord the parties to be second-guessing what I think are usually very good agreements for both sides?
Yeah, there's an interesting case that was decided by Judge Sullivan in United States versus Sienna Tech in D.C. And he accepted the DPA, found basically, he had limited authority as to whether to accept it. But then, for some unknown reason, he addressed half of his opinion as how the government dealt with GM in a totally unrelated case, and their failure really to go after individuals, which is back to what's I guess is the issue of the day, is the importance of going after individuals for responsibility as opposed to just the companies.
Mark, one of the things that we talked about was how are we going to talk about MPAs and DPAs and make this an ethics, what's the ethics angle? So I came up with one, which is there's a judicial ethics element, and there's a canon too. A judge should avoid impropriety and the appearance of impropriety in all activities. So that's a judicial code that might be implicated in situations like that you just mentioned.
What? Could you unpack that a little bit?
Well, when you use the power of the bench, essentially to rule one way, but publicly criticize the prosecution and the so-called failure to prosecute individuals
this is
in
Emmett
another
Sullivan's
instance.
case. I see. Okay, I understand now.
So let me throw the same question to Cheryl, because I guess in SEC versus Citigroup Global Markets, 752 F3rd 285, the Second Circuit rejected the district courts addressing the adequacy of a consent judgment. And so how do you, what's your reaction to that? Does it exceed the judicial power?
I don't want to anger Judge Rakoff or anyone else by speaking specifically about that. I will say that it threw the SEC for a loop when it happened, for sure, when the original decision came down. It had been the practice at the SEC and DOJ to file settled actions and expect that those would be, I guess, to some degree rubber stamped, agreed upon without any scrutiny. And I think this was the beginning of somewhat of a change there. And one of the things that some people think has resulted from that is an increased use of the administrative process to resolve matters at the SEC, particularly now that you can get all the relief administratively that you might have been able to only get through district courts. I don't know if that's the principal reason that you see more administrative resolutions, but I think that might be part of it, particularly when the matter was going to be filed in district court in D.C., because that was the most likely place to file it. But I think that for the most part, those cases are an aberration. In Citibank, the big issue there was no real requirement that there was an admission of liability, for example, and other, certainly lots of other things that Judge Rakoff said were he didn't agree with. I know there were other resolutions, too, that I was associated with in which ultimately the judge may have decided to agree with the resolution, but not without spending a lot of time questioning the government about the adequacy of the resolution, some tough questions for both sides about the remedial efforts at the company, why this was in the best interest of the public. So I think that there's an expectation there might be that scrutiny behind the scenes that doesn't necessarily get known, and in the end the resolution, the consent is agreed upon. So I think one thing you do see is more documentation in the papers now about the thinking behind the resolution and the analysis of perhaps the compliance program at the company or the remedial efforts and the reason why that particular resolution has been reached as a way to perhaps fend off these sorts of criticisms or second guessing of the terms of the agreement.
All right, so just I think we have time for one more set of questions. So there's a lot of activity with whistleblowers or people, employees, bringing you information about their company, whether it be at the SEC or DOJ. Is it ethical for you to accept documents from an employee that maybe had a confidentiality agreement with the company? And would you? And then the second part of that question is, would you tell them to go back and get more?
Are you asking our representative from the government? Yes.
I'll start with you.
Again, it always depends on the facts and circumstances, but the particular instance you mentioned was that the employee is offering up documents, I assume, to which he has lawful, or she has lawful access?
Use that hypothetical, but there's a
That's
confidentiality
part
agreement,
that's
yeah.
part of the question. And the second is if the document is subject to a confidentiality agreement or some kind of non-disclosure agreement. And I think it would depend if that confidentiality agreement contained some kind of exception for cooperating with the government. And many confidentiality agreements have some provision, some carve-out to that effect. So I think it would, again, depend on the facts and circumstances.
Well, Cheryl, the Rule 21F now would preclude companies from enforcing a no contact with the government provision. But does that then allow the government to say, okay, well, get me more information? Or don't you have to use some legal process at that time?
For the most part, the government isn't going to ask you to become their agent and go and gather things, particularly if you're doing it in a way that might, be illegal. They're not going to ask you to secretly tape conversations when you shouldn't or do anything like that. I don't know that the government is necessarily thinking about whether you would have some restriction, and given KBR and the government's view there, you might think the SEC might say, well, we don't care about the fact that the company told you you're not supposed to provide information, we still want it. But for the most part, I would say the SEC doesn't put itself in the position of asking employees to go out and do their work for them.
Well, I think we're about to wrap up, but I think we're kind of seeing where rules, which is what we were discussing this morning, that may be developed either by the amendments to the Dodd-Frank Act or other statutes, are bumping into our ethical obligations. And my real question is, what is the best way to solve that? Because, Charlie, you put yourself, you said it before, you put yourself at risk. And you don't want to be at risk. I mean, how do you resolve that?
Well, the first thing I do is I go see the dry cleaner to ask him how he would deal with the situation, because I get the idea of risk, but that's what we signed on for. You signed on to accept risk while you're doing your job. And I get the delicacy of it, and I certainly have gone through those moments where you're wrestling with, okay, what's the right thing to do here? And that's why, I'm whimsical when I talk about the dry cleaner, but I think the dry cleaner is really the point. And the point is you have, somebody has come to you, some company has come to you, you have a responsibility. And I get the rules, and, you're looking at 1.4 and 4.2. I get all of that. But I think ultimately it has to be how you feel as a person, as a lawyer, as a responsible person to deal with the situation in the moment. And obviously you're going to make sure you don't go across the line and violate some rule. But I think, as I say, it's what we are. And if we're not that, then then what the heck are we?
Mark, the fact is, as a general counsel for a decade now, I've dealt with every section of the ABA. No section has spent as much time exploring the contours of where the rules meet ethics as much as this section does. So when I need to call upon counsel who are going to help me do those evaluations, it's going to be a white-collar lawyer. So I don't know if Ray's here or outside, but the thing that Ray and that little committee of 11 lawyers has grown here is a nationwide group of lawyers who can serve the interests of corporations as clients, of corporate employees, corporate executives, and try, because that's all we can do. The situational ethics reality is all we can do is make our best judgments, and when we get those best judgments in front of Judge Gleeson and his colleagues, they'll let us know if we were right or wrong.
One last thing. First of all, I want to thank Ira for actually writing an article, and it's excellent, and for Vince Foster of Holland and Knight for allowing us to use his series of articles on internal investigations and ethical issues, and also to the Morvillo firm for allowing us to use some of their articles which address some of Judge Gleason's points. And in particular, I want to thank this group of people because this was a real honor to moderate this panel. So thank you.
Thank you.